I rise to support the motion to refer this bill to committee. I think it makes absolute sense. And while I would have loved, like my colleague Rod Caddies, to not have to move this to committee and clog up committees, this is where we are. I do have concerns about this bill, issues with ambiguity of wording. There's an issue around the appeals process. There's an issue around the youth justice element, of course, adding further strain on our courts. The bill as it stands will have unintended consequences. I mean, we just can't ignore that, especially for children under 18, witnesses to crime, bystanders, who just simply post content without any criminal intent. So I do appreciate that we can't do nothing. I have spoken to many communities who are actually grappling with youth crime in their local community, so I'm not oblivious to some of those issues, but punitive measures are just not going to address these underlying issues, especially the issues fueling youth crime in a lot of these areas at the moment. It's a bit like using a flamethrower to remove pests from a greenhouse, Acting President. You'll probably get the pests, but you're going to scorch more in the process. So the reality is, for me, this bill just actually captures a far wide range of people, far more circumstances, and probably far more than we realise. Just another reason to refer this bill to the committee. It risks punishing the innocent. There is an element here where it does silence legitimate public comment, and even destroying evidence that could be critical in holding the state accountable. I mean, at the core, the post and boast element in section 221 makes it a crime to share any material that depicts a relevant offence if a reasonable person might think it humiliates a victim, offends a group, or glorifies or encourages an act. On paper, yep, it might sound like it's targeting violent crimes, but relevant offence, as I mentioned earlier, is very ambiguous. Section 221 includes not just the most serious crimes, but also less serious ones. This would include unlawful assembly, resisting arrest, to even certain traffic offences like burnouts or just noisy driving. So the effect is that even a short clip of a spontaneous protest or a schoolyard scuffle could technically fall under this law. Let's say someone uploads a video of a man who's arrested. He believes he was wrongfully arrested and wants to call attention to this case. Would a reasonable person consider this a glorification of resisting arrest, or perhaps an attempt to humiliate a group? I would consider this situation just a form of civic expression, not because I'm in favour of resisting arrest, but simply because there is a freedom of speech element to this as well. So let's consider that freedom of speech element for a minute. There's a lot of room for error in this bill regarding this. This bill gives courts the power under section 221 to order the removal, deletion, destruction or forfeiture of material, even if there's been no charge or conviction. These rectification orders can be made after an oral request from a prosecutor, or they can be made entirely unilaterally. So these are some really key things that we have to be mindful of. This is the House of Review and we have to scrutinise legislation. Well, I just don't think we're there yet with this piece of legislation. Again, further reason to move this to a committee. I don't know, President, but honestly, this seems to flip the presumption of innocence on its head. Acting President, apologies. Following on from that is how relevant offences is defined. The bill doesn't just target offenders, it also catches bystanders too. So a child who films an incident on their phone and posts it is captured by the scope of this law, as my colleagues have pointed out. The law that states denouncing the conduct is actually a legitimate defence. However, what does it mean to meaningfully denounce something to the court's satisfaction? Again, it comes back to that ambiguity in the language and the need for this to have further scrutiny. Of course, if a minor uploads a video of someone hooning in their car with the caption, let's say, "what an idiot," with a laughing emoji, is that denouncing the behaviour? It's not clear. So the courts would have to determine if this child is liable for $12,000 in fines or 12 months in prison. I mean, again, it comes back to that punitive measure. It's just not going to solve an underlying issue we have with youth crime in our communities. Just another way that the vague definitions are actually already putting a lot of our young people at risk and our youth. There are also risks with the appeal process. Another reason why, again, that in itself should nullify this bill, so we don't even need to go through the process. But currently, section 221 says that there is no right of appeal against a decision to make or revoke a rectification order. This means a single court's decision to remove or destroy your material cannot be considered by a higher court. So this may be the most reckless and dangerous aspect of this bill. Judges and courts are not infallible, Acting President. So I do believe this bill does establish a bit of a two-tier system. Section 221 exempts police, agencies, as the Honourable Brad Pettit pointed out, and those acting in the administration of justice from this offence if they're acting in good faith. Ordinary citizens, though, including children, have no protection like that. So that means the state can post, broadcast or store exactly the same footage without risk, but private citizens could be persecuted for it. Not to mention the government being in charge of determining that it is acting in good faith and giving itself free rein. I mean, that in itself is super problematic. Yes, the government is acting in good faith, says I, the government. Meanwhile, the presumption is that the rest of us are acting with nefarious intent, and of course we face a lengthy court process otherwise. Lastly, I will point to the Justice Commission's suggested amendments. The Justice Commission has proposed 9 of those, and I do think it's a fantastic document to consider. But it includes limiting the scope to serious offences only, exempting private communications, exempting legitimate protests, and of course appeals against these rectification orders. Of course, I'm not here to endorse all of those suggestions, but they are reasonable, and I do think we need to take them into account. There is much more to add, Acting President, but these are just a few reasons why I definitely support this moving to a committee. I do feel that this goes beyond its stated purpose and creates a power of censorship, to seize, destroy without conviction. It exposes children, it clogs up an already at-risk justice system, exposes bystanders, and also it's some serious penalties. So I really do feel for that reason and the fact that it removes the right to appeal for this to actually have further scrutiny. Very prudent, very necessary, and so I move to support that motion. Thank you.